Take a look at this. Could Gary Gensler's resignation or removal lead to a dismissal of the Ripple SEC lawsuit? Following the decision of a federal judge that the United States Securities and Exchange Commission did not prove that Ripple violated securities laws by selling XRP to retail users, the CC has filed an appeal in its case against Ripple. The Securities and Exchange Commission has filed an appeal with the Second Circuit Court of Appeals, arguing that the judge's ruling undermines both established decisions from the Supreme Court and legislation pertaining to securities. The current legal disputes in the cryptocurrency field could be influenced by a number of different things as we look to the future. There is a possibility that the direction of the Securities and Exchange Commission could be altered due to the impending election. It is possible that the existing dynamics may undergo a significant adjustment if Donald Trump wins. Concerns come regarding the manner in which continuing litigation is deterring innovation from taking place in the United States. There are two possible scenarios that could occur as a result of this issue, according to James Murphy, also known as Metalaw Min. Either Gary Gensler resigns from his post or he is removed from his job and replaced by someone who is less hostile towards crypto. As an alternative to taking harsh proceedings against the sector, a new leader can make the resolution of litigation or the dismissal of cases their top priority. James emphasized the significance of the impending presidential election for the regulation of cryptocurrencies. Despite continued efforts to regulate the cryptocurrency business, which have been called Operation Choke Point 2.0, he pointed out that Kamala Harris was recently unable to correctly identify any faults that the Biden administration had done in relation to cryptocurrency. It is also important to note that there is legislation now being drafted that has the potential to clarify jurisdiction over Bitcoin. This suggests that it may be impractical for judges to determine these matters without clear directions from Congress. In light of this environment, there is a probability that is larger than 50% that we will witness developments that will cause these situations to go a different path. He went on to say that powerful people such as Mark Cuban and Anthony Scaramucci have brought up the possibility of changes occurring in the near future, but he is skeptical about this. Due to the fact that the election is only a few weeks away, he brought up the fact that the administration might simply request Gary Gensler's resignation, and in most cases, such requests are complied with. Nevertheless, he voiced his dissatisfaction with the fact that little seems to have been done as of yet. The XRP community is going ballistic over the latest development in Ripple's protracted legal battle with the SEC. Ashley Prosper recently released a post on X that explained the next steps in the appeal process. This sparked a chain reaction from influential community members, as Ripple's success is contingent upon meeting crucial legal deadlines. More and more people are starting to believe that the dispute may be resolved. The settlement conference between the CC and Ripple is imminent, following the docketing of the Securities and Exchange Commission's appeal. Ashley Prosper's article offered a thorough analysis of the legal process. As Prosper mentioned, the case has been forwarded to the camp office where a settlement meeting is scheduled to take place. Prior to this conference, both sides should have thoroughly prepared to debate procedural, legal, and factual issues. Also, lawyers need to have pre-negotiation conversations with their clients to secure as much bargaining power as possible. Taking part in this process actively is not something you can choose to do if you don't want. The court has the power to punish parties that do not adhere to the assumption that both the clients and the attorneys will behave in good faith. There is now more hope that a solution might be around the corner thanks to the completion of this crucial phase. Both the event and the swell are scheduled to occur on October 16th, which is the deadline. A community member by the name of Mickey Sexarp asked, when the SEC is required to reveal the details of the appeal, it is challenging. And the question was answered almost instantly. The 16th of October has been set as the deadline, according to Ashley Prosper's response. This is also the last day of Ripple's swell event. Scheduling rumors have circulated as a result, and many are keeping their fingers crossed that Ripple CEO Brad Garlinghouse will make a major announcement before swell ends. Since the legal deadline in Ripple's most important event happened to be at the same time, Ben Lemaire made a humorous statement about how he hopes Garlinghouse would announce that the legal disagreement with the SEC has been finally addressed. A lot of people are wondering if the battle between Ripple and the SEC will reach a major turning point when a switch flips. It is possible to withdraw the appeal to the SEC. As the deadline approaches, speculation is rife that the Securities and Exchange Commission may drop its appeal. Many are wondering if the regulatory body will change its mind given the recent court judgment. that favored Ripple in the timing of the announcement. Rumors are circulating that the SEC is pulling out of the case, even though there is no proof of this at this moment. Even though a judge ruled that XRP is not a security, the SEC is now claiming that it might be able to function illegally. Following that, he promised to closely monitor developments and look into potential options for taking action that could bring the Securities and Exchange Commission to justice. This action will be based on his criticisms of the SEC's overreach and attacks on the alleged shared control that the SEC is meant to perform over XR futures contracts, since he believes it was an unconstitutional overreach. The exchange maintains that the SEC does not have authority over XR futures because they are not securities. Reason being, according to the exchange, these contracts are not securities. This is in line with what garlinghouse has said regarding the SEC's persistent overreach into regulation, which he thinks hinders development and innovation within the Bitcoin industry. This lines up with what garlinghouse claims, that Ripple is embroiled in ongoing legal disputes. Contrary to popular belief, Ripple has been suing the SEC in an unlawful manner since December of last year. The SEC took legal action against Ripple after the business sold XRP worth $1.03 billion in unregistered securities offerings. The whole time the lawsuit was underway, Ripple maintained that XRP was not a security position. In July 2023, District Judge Analisa Torres largely upheld this claim in her ruling that XRP programmatic sales on exchanges that are publicly traded do not constitute transactions of securities. The regulatory picture remains quite unclear, despite her directive indicating that security transactions can include direct sales of XRP to institutional investors. Ripple responded to the SEC's appeal of the judge's judgment by filing a cross appeal for the judge's decision. Several conflicts regarding the ability to regulate cryptocurrencies are happening between the that quickly growing cryptocurrency industry, and the Securities and Exchange Commission. The disputes have often led to Stuart Alderodi, Ripple's chief legal officer, and his colleagues criticizing the company loudly and persistently. It seems like they've seen some cess overreach and some constitutional problems with the limits of its regulating power, industry responses, and demands for clarification. In response to garlinghouse's accusations on the Securities and Exchange Commission group, many in the Bitcoin world have expressed their indignation. As far as this group is concerned, the CESA's moves are indicative of a larger problem with the industry's lack of regulatory clarity and work against innovation. Given the expected ongoing development of cryptocurrency markets, the extent to which these legal conflicts may influence the regulation of digital assets in the US is currently uncertain. This already convoluted situation has become even more so due to industry reactions and pleas for clarity on the part of the Securities and Exchange Commission and the Commodity Futures Trading Commission. Although the SEC is adamant about regulated securities, the CFT digital assets see Bitcoin contracts as commodities, according to KepTech, a member of the Commodity Futures Trading Commission. Given that Ripple and most other cryptocurrency companies are presently navigating through some rough waters with regulatory updates, a lot of other cryptocurrencies have grown substantially, while XRP has lagged behind. Not only that, but the trading advice should not be construed from the data that has been supplied. Any investments derived from the data shown here are entirely at the investor's risk. We recommend that you do your own research and talk to an expert before making any investing decisions.